Hello everyone, welcome to Bajirao IAS Academy. So in today's class we have some important topics for Gender Studies paper 2. So we all knew that Gender Studies paper 2 in mains examination is one of the very important paper, and it is a dynamic paper. And dynamic paper in the sense that you need to up to date with the regular things that have been taking place. So if you look at the syllabus of Gender Studies paper 2, it consists of Indian polity, Indian constitution, governance, social justice and international relations. So therefore you need to be adequately prepared to this particular paper. And if you have a strong hold on these important topics or the concepts, along with some important constitutional articles, constitutional provisions, judgments of the Supreme Court and key legislations that have been passed. So if you have a strong command over these areas, there is a very high probability that you could score very good marks in this paper. So the overall objective of discussing Gender Studies paper 2 is to make sure that you adequately equip with all necessary content, knowledge to write best answers in this paper. So if you look at the trends also, this is one paper where you could score good marks even if you perform above average. So therefore make sure that you have a strong command on different concepts in the sense that, for example, secularism in India is a big debate. Apart from secularism, new constitutional amendments have been brought in. For example, 106th Constitutional Amendment Act that has provided 33% of the 33% reservation for women in Lok Sabha and state legislative assemblies, and how it could translates into the political empowerment of a woman. So along with that, the 73rd and 74th Constitutional Amendment Act, grassroots level democracy, devolution of powers, center-state relations. So all these areas are some of the important areas in this paper. So in the coming days, what we actually do is we pick up some important topics. So we'll try to discuss them in a detailed manner, so that this discussion will be helpful for your examination and you will be adequately equip yourself with all necessary content to deal with this particular paper. So however, before discussing, it is important for us to understand trends of Gender Studies paper 2. Now, how questions are being asked, how many questions are being asked from this particular paper? Now you should understand one thing, that in Gender Studies paper 2 also, governance and social justice are these two topics are a part of Gender Studies paper 2. And apart from governance and social justice, we have also discussed that Indian constitution, Indian polity and international relations. But from the governance point of view, one very important question is self-help groups. So self-help groups is a very important topic, and you should adequately prepare for this topic, and we will also discuss about self-help groups as well in our coming lectures. And apart from that, you can also see fundamental rights which are enshrined in the Indian Constitution. So they are also very important, particularly Article 19 of the Indian Constitution, Article 21 of the Indian Constitution, because Article 21 of the Indian Constitution is very dynamic, it is evolving in nature. And over a period of time, through the interpretations of the judiciary, particularly the Supreme Court, number of rights are included in Article 21 of the Indian Constitution. So one example is in Puttaswamy judgment, the Supreme Court has included the right to privacy as a fundamental right. So therefore, fundamental rights are also a very important topic, and in fact, number of questions are being asked from this topic. And Representation of People Act is directly given in the syllabus itself. So when we talk about the Representation of People Act, it deals with some questions like criminalization of politics. This is a very important area. Criminalization of politics. And apart from criminalization of politics, so different things are being asked from the Representation of the People Act. But one area is the criminalization of politics. So we will also discuss about this. And you should not forget that comparison of Indian constitutional scheme with that of other countries is one of the very important topic, because so if you look at the UPSC previous year questions of general studies paper 2, this question from this particular topic has been asked right from 2018 every year up to 2023. And even questions from center-state relations are also asked, particularly centralization of powers through number of measures. For example, you could see that there's one nation, one election, goods and services tax. So in number of areas there is a heavy centralization of powers, and the potential of interstate council has not been utilized to protect the federal spirit of the Indian constitution. So therefore, center-state relations is another area that we should discuss, along with cooperative federalism, collaborative federalism, competitive federalism. And similarly, parliament and state legislature, this is also a very important topic, right? So in the context of, speaker, the office of the speaker is a very important area. Apart from that, the parliamentary committees is also another very important area. And similarly, we should talk about declining parliament. So that essentially the very less number of bills are being referred to the parliamentary committees. And question hour or zero hour, so the number of questions are being asked, or increasing absenteeism of the member of parliament. So those are the important topics. And apart from that, separation of power and judiciary is also another very important area. So when we talk about judiciary, it is very important to look into judicial overreach and even judicial activism. Judicial activism is also another very important area from which questions could be asked. And even separation of powers is also another very important. Separation of powers between executive, legislature and judiciary. And even devolution of powers, delegated legislation. So all these are important topics. And similarly, so functions and responsibilities of the union government and the federal structure. What is federalism, and what are the threats, challenges that federal structure in India has been facing? How to protect the federal structure, how to strengthen or enrich the federal structure. So these are some important questions. And similarly, constitutional bodies, statutory bodies, quasi-judicial bodies and regulatory bodies such as National Human Rights Commission, National Commission for Backward Classes, National Commission for Scheduled Castes, Finance Commission, and even Election Commission of India. So questions are being asked from all these topics, but if you get to know about the fundamentals of, for example, National Human Rights Commission, if you get to know about the fundamentals, you could write the answer. And that's the focus of this discussion. And apart from that, governance and social justice also, international relations also, number of questions are asked. And one very important topic is education, healthcare, poverty, hunger, vulnerable sections and welfare schemes that are launched by the government for the benefit of these welfare, for the benefit of vulnerable sections, non-governmental organizations, civil societies, pressure groups, e-governance and role of civil services in a democratic country like India. and India's relations with other countries. So see, these are all important topics, but make sure we discuss some important topics in this paper so that you could adequately prepare yourself and you could also write best answers, and that ultimately helps you score good marks. Now, the first topic, we briefly try to understand about the constitutional amendments in India. So constitutional amendments, so what are the important amendments, constitutional amendments? So how amendments could be made, and what is the importance of amending constitution, whether Indian constitution is a flexible constitution or a rigid constitution. So we'll try to understand this. Now, in fact, India's constitution is known as a living document. So it is known as a living document because from time to time amendments could be made to the Indian constitution. It is not a rigid constitution and it is not a flexible constitution also. So it is a mix of rigidity and flexibility. So therefore, from time to time, based on the needs of the society, amendments to the constitution can be made. And in fact, Indian constitution, it is being said that it is a testament that has actually seen India's successful transformation from a colony to a sovereign republic. Now, India is a sovereign republic. We have our own government, we have our own constitution, right? So because of that particular reason, India is now a sovereign republic, and the constitution has played a very important role in the transformation of India from a colony to a sovereign republic. So in fact, you could write this in the introduction. And similarly, the other thing that you could also mention in the introduction whenever any question on Indian constitution or constitutional amendments is being asked, that Pandit Jawaharlal Nehru, he also stated that Indian constitution is dynamic. It is not a static in nature. Now, what is static? So static constitution is the constitution which is rigid, and constitutional amendments cannot be made from time to time. Changes in the constitution cannot be made from time to time. But on the other hand, Indian constitution is a dynamic constitution. It is a living document. And in fact, Pandit Jawaharlal Nehru has also highlighted that we would like to make Indian constitution a permanent constitution. This should not be a temporary constitution, rather a permanent constitution. But however, in order to remain a constitution, a permanent constitution, it should allow amendments, so that over a period of time, when society rapidly progresses or society gradually making progress, it is important to bring in amendments to the constitution, and that's how we could ensure that the constitution of any country is a permanent constitution. So therefore, he visualized Indian constitution as a permanent constitution, and at the same time he wanted that Indian constitution should have a certain degree of flexibility, so that it could adapt to nation's growth as well as the changing conditions that have been taking place over a period of time. So how many times Indian constitution has amended? So far 106 amendments have been made to the Indian constitution. So the recent constitutional amendment is providing 33% of the reservation for women in Lok Sabha and state legislative assemblies, and that is 106th Constitutional Amendment Act. And one very important article in the Indian Constitution that deals with the amendment of the Indian Constitution is Article 368. So Article 368 provides a procedure for the amendment of the Indian Constitution. So you should have to remember Article 368 of the Indian Constitution. So far 106 amendments to the Indian Constitution have been made. So Article 368 of the Indian Constitution mentions an elaborate procedure for the amendment of the Indian Constitution. However, Constitution can be amended in three different types. It could be amended through three different types, and the first type through which Indian Constitution can be amended is a simple majority of Parliament. Who could actually amend the Parliament? Who could actually amend the Constitution? Parliament is given the power to amend the Constitution. Not even the state legislative assemblies, but only Parliament could actually amend the Constitution. Right? So what is the procedure? The first way through which Constitution can be amended is amendment by simple majority of the Parliament. So there are certain provisions in the Indian Constitution, such as establishment of new states, alteration of boundaries of the existing states, and also abolition or creation of legislative councils in states. So those are the certain provisions in the Indian Constitution. They require just a simple majority in the Parliament to amend. And this is one procedure. However, these amendments are not really considered as the constitutional amendments, because it just requires a simple majority. Apart from that, regular amendments have to be made to the Indian Constitution when it comes to these different provisions, and because of that reason, this first procedure is not really considered as a constitutional amendment. However, there is a second procedure also through which Constitution can be amended. So in the second procedure, Parliament requires a special majority to amend a certain features of the Indian Constitution. In the first procedure, simple majority is required. That means some provisions in the Indian Constitution can be amended with just a simple majority, but in the second procedure, there are some provisions which require a special majority in the Parliament, such as fundamental rights, directive principles of state policy, etc. They certainly require a special majority of the Parliament, and this is the second procedure. And the third procedure is amendment by special majority of Parliament. Apart from that, half of the state legislatures must ratify the constitutional amendment bill. Right? So this is the third procedure, and it reflects a rigid nature of the Indian Constitution, because it not just requires a special majority of the Parliament. Apart from that, it also requires the consent of the half of the state legislatures as well. Half of the state legislatures must ratify the constitutional amendment bill to become a constitutional amendment. So what are the provisions which require the special majority in the Parliament along with half of the state legislature's consent? That is the election of the president, the extent of the executive power of the union government, state government, provisions with respect to Supreme Court and High Court. So constitutional amendment on these different provisions or features of the Indian Constitution requires the special majority along with consent of or ratification by half of the state legislatures. However, this is considered as a formal amendment procedure of the Indian Constitution. However, apart from formal amendment procedure, there are also certain ways through which Constitution can be amended. So that is what is known as informal amendments to the Indian Constitution. So how informal amendments to the Indian Constitution could be made? So they could be made through judicial interpretations. Judicial interpretations is one way through which constitutional amendment can be made. Secondly, constitutional conventions. So constitutional conventions is also another way through which amendment to the constitution has been made. Now, for example, in Keshwanand Bharati judgment of 1973, the Supreme Court has provided for the concept of basic structure doctrine. Now, here, what exactly is concept of basic structure doctrine? So that essentially means that Parliament can amend any part of the constitution, but the amendment should not destroy the basic structure of the Indian constitution. So this is what the basic structure has been talking about. However, there is no proper codification, there is no fixed features of the Indian constitution which could be part of the basic structure. However, the Supreme Court from time to time has been pronouncing new features of the Indian constitution which could be part of the basic structure. For example, the parliamentary form of government in India is considered as part of basic structure. And secondly, rule of law is also considered a part of the basic structure. Secularism is also considered as part of the basic structure. So Parliament can actually amend any part of the constitution, but the amendment should not destroy the basic structure doctrine, and that is the concept of the basic structure doctrine given by the Supreme Court in Keshwanand Bharati judgment in the year 1973. So therefore, this judicial interpretation or pronouncement is also considered as an amendment to the Indian constitution, but this is an informal amendment. Now similarly, there is also some constitutional conventions as well. For example, a convention that Prime Minister is considered as the leader of majority party in the Lok Sabha, that is the lower house of the parliament. It is nowhere mentioned in the Indian constitution, but it is a healthy convention that has been developed. A healthy convention that has been developed and followed by the political system in India. Right? So what is that convention? The convention is that Prime Minister being the leader of the majority party in the Lok Sabha. So we have understood the formal amendments which are being done to the Indian constitution and informal amendments also. However, we will understand the necessity of the constitutional amendments. Now, why constitution has to be amended? What is the reason? So, in case if we have the constitution that has been framed by the Constituent Assembly, so why Constituent Assembly has provided for the amendment of the constitution? And that is why Indian constitution has been called as a living document. Otherwise, it cannot be called as a living document if it is not permitted to amend. Right? So because of that particular reason, Indian constitution is considered as a mix of rigidity and flexibility. A mix of rigidity and flexibility. So flexibility in the sense that Indian constitution can be amended easily. Indian constitution can be amended with ease, that we have seen during the procedure of amendment of the constitution. However, Indian constitution, there are some provisions of the Indian constitution, they cannot be amended with that ease. So that reflects the rigid nature of the Indian constitution. For example, special majority is required. Special majority with the consent of half of the state legislatures is required. Right? So therefore, it is a mix of rigidity and flexibility. Now, what is the necessity of the constitutional amendment? Now, we are living in a society where the society is not stagnant. Society changes over a period of time. However, any constitution should keep a pace with the changing nature of the society, changing needs of the society. Right? So Indian society is also considered as a dynamic and evolving society. So in this dynamic and evolving society, Weaker sections have to be protected with adequate safeguards, not just the weaker sections with new needs emerging. For example, 102nd Constitutional Amendment Act. So that has been provided constitutional status to National Commission for Backward Classes. 103 Constitutional Amendment, and that has provided for the economically weaker sections 10% of the reservation. And 106th Constitutional Amendment, that has provided 33% of the reservation for women in Lok Sabha and the state legislative assemblies. Right? So therefore it is important to protect the interests of the weaker sections. So constitutional amendment is not just for the interests of the weaker sections. So there are several reasons because of which constitution has to be amended regularly. However, as I have already discussed about the 106th Constitutional Amendment, that has been provided 33% of the reservation. It is expected that through this particular act, Constitutional Amendment Act, it would result in the political empowerment of women. Political empowerment of women as it increasing women's participation. And apart from that, it would also strengthen the institutions, the existing institutions. Right? So in order to strengthen existing institutions also, you need to amend the constitution, right? Because that could ensure, India is a functional democracy. India is a healthy democracy. So for instance, Indian Constitution framed 52nd Constitutional Amendment Act. So this 52nd Constitutional Amendment deals with what? It deals with the anti-defection law. Right? So it deals with the anti-defection law. Now, what exactly is this anti-defection law? So it is important for us to understand the anti-defection law. For example, if you look into Indian politics very closely, now in Indian political system, the democratic culture is absent. So there is a lack of inner party democracy in Indian political parties. And because of this reason, very often corruption, horse trading, and frequent defections by the political party, members or elected members of a political party from one party to another party, purely out of self-interest, has been taking place very regularly. And that has resulted in a huge instability in Indian political system. So in order to arrest the instability in the Indian political system, now why defection leads to instability? I hope you knew about this. So why instability, why political defections cause instability? Because, if a particular political party decided to form a government, the political party must require a certain majority. If political party fails to get a certain majority, then it could not form the government. So even if it forms the government, it should be able to retain the majority in the state legislature. So because of the defections, some members from either the ruling political party or opposition political party, they just switch sides, and that could create instability, and that would also result in conducting fresh elections in that particular state or imposition of the president's rule as well. So therefore, in order to avoid this situation, anti-defection law has been framed through the 52nd Constitutional Amendment Act. So anti-defection law aimed to prevent defections, the politically motivated defections. Now, what are the grounds what are the grounds based on which the anti-defection law would be applied? So there are certain grounds. For example, the elected member of a political party votes against the wishes of the political party that he belongs to, then also the anti-defection law would be applicable. An independent candidate joins any political party after his election, then also he will be disqualified under anti-defection law. And a nominated member of the state legislature or even Lok Sabha joins any political party after 6 months, then also he will be disqualified under anti-defection law, right? So this aims to ensure the stability in the political system by preventing the defection of the elected members from one party to another party. And similarly, technological advancements, right? So in any society which has been making rapid and regular progress, technological advancements play a very important role. So in fact, new technologies can actually necessitate a legal framework. For instance, right to privacy as a fundamental right that has been recognized by the Supreme Court in Puttaswamy judgment. So we are living in an age of digital technology. In an age of digital technology, everyone's privacy has been violated. State surveillance incidences have been increasing. So therefore, privacy has gained a lot of importance at the international stage and even in India itself. And in 2017, the Supreme Court has recognized that right to privacy is very important. So therefore, it should be included as part of Article 21 of the Indian Constitution. So even though no such amendment has been made by the Parliament, through the judicial interpretation, right to privacy has been added to the Article 21 of the Indian Constitution. Right? So therefore, we could conclude that technological advancements also one reason for the amendment of the Indian Constitution. Now, in fact, fulfilling social contract is another area which mandates or which requires the amendment of the Constitution. And in fact, the Gandhian vision of having Gram Swaraj. So Gandhi very often talked about Gram Swaraj, not just Gram Swaraj, but also the self-sufficient villages. How can Gram Swaraj could be achieved? So it could be achieved through the participation of people at the grassroots level governance and the decentralization of democracy. Decentralization of democracy. And apart from decentralization of democracy, grassroots governance. So these are the ways through which Gram Swaraj could be achieved. This is Gandhian vision of India. And in fact, in order to achieve the Gandhian vision, 73rd and 74th Constitutional Amendment Acts have been framed by the Indian Constitution in the year 1991. So therefore, it has resulted in decentralization of democracy, participatory governance, and the grassroots level democracy in India, and that will help achieve or realize the dream of Gram Swaraj as it was envisaged by the Mahatma Gandhi. Right? So we have understood why constitutional amendments are required, why constitutional amendments are very important. So we will understand what are the issues that are existing with the constitutional amendments. So in fact, constitutional amendments also comes with the certain issues as well, and it is important for us to understand those issues as well. So firstly, if you look at the Indian amendment procedure, so Indian Constitution and the US Constitution. So US Constitution is a very rigid constitution that you cannot easily make amendments to the US Constitution. But on the other hand, Indian Constitution is a mix of rigidity and flexibility. That means you could amend the Indian Constitution And amendment of the Indian Constitution is comparatively easier than the amendment of the US Constitution. So therefore, 75 years of independence, Indian Constitution has been amended for 106 times, but in US it is around 30 or 25 times. That's it, right? So US was a much older democracy than than India. So therefore, the frequency of amendment in India is very, very high. Now, in fact, 42nd constitutional amendment itself is called as the mini constitution. Mini constitution because a number of amendments have been made through the 42nd Constitutional Amendment Act itself. So because of that reason, it is known as the mini constitution by the Indira Gandhi government, right? So it was done during 1976. So apart from that, the other issue with the Indian constitutional amendment is that, a shift of power. So the shift of power is another issue within the Indian constitution, because when you are making a huge number of amendments to any constitution, there is a very high probability that you probably shift the balance of power between the various institutions. Maybe legislature or executive or a judiciary having more and more powers. So one organ of the government is having more power over the other organ of the government, right? So that will not ensure a balance of power, and that will also impact the checks and balances between these organs as well. So therefore, it could potentially leads to what? It could potentially leads to creation of instability in a political system. Particularly, we don't have the presidential form of government, but we have the parliamentary form of government. Now, parliamentary form of government is more and more vulnerable to such instability, and instability is not good for the growth and development of any country. Right? So when you are making frequent amendments to the Indian Constitution, of course, it would lead to the instability in a political system. And in fact, when constitutional amendment has been made, so one very big criticism of the constitutional amendment is that it lacks public deliberation. It lacks consultations with the stakeholders. Now, when you consider any democracy as a legitimate democracy, so legitimate democracy should get its powers from the public, right? So public would be ultimately taking decisions in a democracy, and that democracy is considered as a legitimate democracy. But when you are making amendments to the Indian Constitution, you are not consulting the relevant stakeholders. There are no extensive public discussions on the amendment of the Indian Constitution. So therefore, it has been raising concerns about the democratic legitimacy in India. So therefore, this is also one of the main concern. And apart from that, constitutional amendment is a very often have a huge potential for the majoritarianism, right? So in fact, if you look at Indian political system, after 2014 we have been observing one party dominant political system. We have been observing one party dominant political system because one single political party has a huge domination, and in fact, opposition also lacked numbers to criticize the government or to play an effective role as a opposition political party. So therefore, whenever you have a strong central government, so strong central government means it is also having a huge majority in the parliament. So therefore, that would result in the constitutional amendments because they have the numbers, they have the majority. So they could frame, or they could bring in the constitutional amendments, so that would certainly benefit their agenda, that could certainly benefit their ideologies, and that could even impact the minority viewpoints as well. So therefore this is another major concern with respect to the constitutional amendment. And in fact, the Supreme Court has also given the basic structure doctrine in Keshwanand Bharati judgment in the year 1973. So we have discussed about this as well. And this is considered as one of the very important and landmark judgment in the history of India, because 13 judges sit on this particular Keshwanand Bharati case. And this case has established the doctrine of the basic structure. And however, when we talk about the doctrine of the basic structure, the scope of the basic structure is remain debated, because there is no legislation framed by the parliament that talks about the basic structure doctrine, and there is no constitutional provision which talks about the basic structure doctrine, but it is just a judicial pronouncement, it is just a judicial interpretation, it is not codified. So therefore it imposes restrictions, it imposes limitations on the amendment power of the Indian amendment power of the Parliament of Indian Constitution. So therefore there is a huge uncertainty with respect to amendment process, because we don't know, apart from the already provided provisions of the basic structure doctrine, Supreme Court has also been evolving new features of the basic structure doctrine over a period of time. So however, we will understand the criticism of the basic structure doctrine, criticism of the amendment of the Constitution. So why constitutional amendment procedure has been criticized? Now in fact, centralized control. Now centralized control in the sense that, as we have already discussed, that the constitution can only be amended by the parliament, and the state legislature cannot initiate the amendment of the constitution. But when it comes to US, so US constitution amendment can be initiated by the states. But in India, the constitutional amendment cannot be initiated by the state legislature. So therefore, the power to amend the constitution rests heavily with the parliament, but not with the state legislature. So individual states' voice with respect to the amendment of the constitution is not taken into consideration. It is not given adequate weight also. So therefore it could lead to the neglect of the federal balance in India, and it is also considered against the spirit of federalism in India, right? So however, Article 368 of the Indian Constitution, so it talks about the amendment procedure of the Indian Constitution. So one type of the amendment of the Indian Constitution is a special majority required in the parliament. Along with the special majority in the parliament, ratification by the half of the state legislatures is also required for a constitutional amendment bill to become a constitutional amendment, right? So this is the only thing where the constitutional amendment, where the state governments or state legislatures also have a role in the amendment of the constitution, right? So we have a federal structure. In federal structure, state should also be given adequate weight when it comes to the amendment of the constitution. The second provision is limited public participation. So limited public participation is another area of concern with respect to the amendment of the constitution. So we have just discussed that all relevant stakeholders are not participated in the decision making when it comes to the amendment of the constitution, and in fact, public are not active participants in the amendment of the constitution. So therefore the current amendment process actually lacks the provisions for direct public involvement, such as referendums. In several developed countries, referendums still takes place about different matters. But we don't have a such mechanism such as referendum, initiative, right to recall, plebiscite. So those are the initiatives which are considered as the initiatives of the direct democracy. But they are absent in India to take decisions, to make decisions even with respect to the amendment of the constitution. And it is also said that there should be a dedicated body, because this dedicated body would look into the constitutional amendment, would analyze the provisions which are part of the amendment bill. Thereby, it could make adequate suggestions about the amendment of the constitution, so that could be more democratic, right? So it could not be done solely based on the whims and fancies of the government of the day. So this is also another major problem, right? So this could potentially streamline the process and also ensure a more comprehensive review as well. And in fact, so there are certain amendments which are considered similar to the ordinary bills. So therefore, there should be a more rigorous procedure for the amendment of the constitution that has to be introduced to bring in some fundamental changes in the Indian constitution. And apart from that, there is also a state ratification ambiguity. Now, what exactly is the state ratification ambiguity? For example, it is being said that half of the state legislature must ratify the constitutional amendment bill, so along with the special majority for certain provisions of the Indian constitution. However, there is no specific timeline given for the states within which state legislature must give their consent. So this is also another major problem, right? So constitution itself doesn't mention any time frame for state legislature to ratify the amendments, and that has been leading to potential delays as well as the uncertainties in the amendment of the Indian constitution, and that has to be avoided. So in fact, no attempts were made to resolve the deadlock that is existing between the parliament, state legislature, between the two houses of the parliament. Now, one thing that you need to understand, whenever we are talking about the amendment of the constitution, the constitutional amendment bill can be initiated by the either house of the parliament, either Lok Sabha or the Rajya Sabha. However, the constitutional amendment bill must be approved by the both houses of the parliament. So even if one house rejects, so it will not become a constitutional amendment. And the other thing is that you cannot hold a joint session for the constitutional amendment bills. And when both houses of the parliament passes a constitutional amendment bill, and then it's sent to the consent of the president should also give his assent to the bill. So he cannot reject the assent to the constitutional amendment bill. So therefore, in this context, what should be the way forward in the amendment of the constitution? So there should be actually a dedicated body that has to be established, because this dedicated body, once established, it could analyze the proposed amendments of the Indian constitution, and at the same time it could also make appropriate suggestions, as it provide a more rigorous review process and also prevent hasty changes in the Indian constitution. Thereby we could prevent frequent amendments to the Indian constitution, right? So frequent amendments in fact destroy the basic character of the Indian constitution. So we need to set up a dedicated body or a committee for this particular purpose. And similarly, a joint parliamentary committee that consisting of members from the both houses of the parliament should involve representatives representatives from the political parties, representatives from both houses of the parliament. So what it leads to, it leads to the consensus building, right? So it leads to the consensus building. So apart from consensus building, it also ensures a broader consideration of the proposed changes. Now, one criticism of the amendment of the constitution is that stakeholders are not involved, and there are no deliberations with the public. There are no mechanisms such as referendums when it comes to the amendment of the constitution that takes into account the views of the public about the constitutional amendment. So in order to overcome this criticism, there is a need for a consensus building when the parliament has been amending the Indian constitution, and that could be achieved through a joint parliamentary committee. And this joint parliamentary committee should consist of members of parliament. Along with members of parliament, it should also consist of the political parties as well. And apart from that, there should be a deadlock resolution mechanism. Now, what exactly is a deadlock resolution mechanism? For example, as I have already told you, that any constitutional amendment to become a constitutional amendment bill to become a constitutional amendment, so it must be ratified, or it must be accepted by both houses of the parliament, both Lok Sabha and Rajya Sabha. So what if there is a disagreement between the lower house and the upper house? So the constitutional amendment bill will never become a constitution amendment, because there is no resolution of deadlock. There is no procedure, there is no way to resolve the deadlock between both houses. So therefore there should be a mediation, joint committees has to be set up, and even a temporary supermajority. So these kind of initiatives are required to resolve deadlock between different houses. And apart from that, it is also very important to actively involve the state legislature as well, true to the spirit of federalism. So it is very important that we need to protect the federal spirit of the Indian Constitution, because state government's active participation in the amendment process would ensure a balanced federal structure, right? So it plays a very important role in maintaining the balanced federal structure. And the other thing is that there should be a time-bound ratification on the part of the state governments as well, because Constitution has not mentioned any specific time frame within which the state legislature must accept the bill or reject the bill. So therefore there should be a time-bound ratification of the constitutional amendment bills, and that could effectively prevent indefinite delays as well. Now, in this context, constitutional amendments are considered as vital and very important mechanisms to keep the constitution relevant, and also keep constitution adaptable to the dynamic world. So therefore we must do the amendment of the constitution regularly, because we are living in a dynamic world. So dynamic world makes that we should be adaptable to the changing times. However, it is very important that whenever we are amending the Indian Constitution, it has to be done judiciously and sparingly, essential to safeguard the integrity and stability of our foundational values. So I hope you have understood about the amendment procedure of the Indian Constitution, right? So the next topic that we are going to discuss is 106th constitutional amendment. So this is also a very important, because recently it has been brought in, that aimed at providing 33% of the reservation for women in Lok Sabha and the state legislative assemblies. So this Women's Reservation Bill of 2023 is also known as Nari Shakti Vandana Abhinayam. Right? So you have to remember this. This is also known as Nari Shakti Vandana Abhinayam. Right, so Nari Shakti Vandana Abhinayam of 2023, as I have already told you, it reserves 1/3 of all seats in the Lok Sabha and state legislature or state legislative assemblies, and even National Capital Territory of Delhi Legislative Assembly for women, and the objective is the political empowerment of women, or strengthening the participation of women in the legislature. Right? So what is the significance of Nari Shakti Vandana Abhinayam? So it is very important for us to understand the significance. The significance is that, if you look at even the 17th Lok Sabha, 18th Lok Sabha, so the participation of women is just 14% of the total members of the Lok Sabha. So it is significantly less than most of the developing countries in the world, and even for that matter the underdeveloped countries also. So therefore a need has been felt in a patriarchal society that women's representation in the parliament and state legislative assembly must be enhanced through a legislative measure. So that is this Nari Shakti Vandana Abhinayam. So it aims to increase women's political participation. So a primary focus of this particular amendment is that it enhances women's political participation, and it also promotes a gender equality in the government. Similarly, it can potentially lead to better representation of women's issues and also the perspectives in the policy making. Similarly, it may inspire more women to enter into the politics, breaking down the traditional gender barriers. So it is very important that we should break down the traditional gender barriers. So that could be possible when more and more women are coming and they are entering into the politics. However, it is not free from criticism. Right? So in fact, the Nari Shakti Vandana Abhinayam has also been facing certain criticism. There are also certain shortcomings as well when this amendment has been brought in. Now, what are those shortcomings? And in fact, it is a rotational system. The reservation for women is based on a rotational system. So therefore, since it is a rotational system, it might be a disadvantage for women with long-term political aspirations. So rotational system in the sense that, one particular constituency may be given for the woman, and in the next elections, there is no guarantee that that constituency is again given to the woman. Right? So therefore it is a rotational system, and that could certainly have concerns because there's no guarantee that this particular constituency has been reserved for women for a longer period of time, and that would certainly a disadvantage for women with long-term political aspirations. And in fact, it is expected that the Nari Shakti Vandana Abhinayam will also impact the existing reservations as well, because it might dilute the existing reservation has been provided for the scheduled caste and scheduled tribes as per their population proportion. And in fact, the Nari Shakti Vandana Abhinayam has also been criticized as a quota within quota, because the implementation of this particular constitutional amendment bill and reservation within reservation for the scheduled caste and scheduled tribe women has been raising questions about the further complexities and potential challenges in the implementation of this Nari Shakti Vandana Abhinayam. So in fact, it focuses on numbers rather than the capability. It focuses on numbers rather than enhancing or strengthening women's ability to enter into politics and their ability to play a larger role in the political system as well. Right? So in fact, some critics have been arguing that reservation alone might not guarantee a capable woman representatives. And what happened at the grassroots level? Now remember, at the grassroots level also 33% of the reservation has been given through 73rd and 74th Constitutional Amendment Acts. So despite 33% of the reservation has been given, there is a system called, a concept called Sarpanch Pati or Pati Panchayat system has been started developing. So therefore, it has been masking the true potential of women, because on behalf of women, men are taking up the responsibilities, right? So this is also another major concern. And in this context, we will understand the basic structure of the Indian Constitution as well. What exactly is this basic structure? What is the significance? What are the concerns? So all those things we'll try to understand. This is also a very, very important topic. Now, when we talk about the basic structure doctrine, we have already get to know about this. The Keshwanand Bharati judgment of the Supreme Court has given this basic structure doctrine. But before the Keshwanand Bharati judgment also 1960s and 1970s. So this basic structure doctrine has been evolving over a period of time, but it ultimately culminated into, this basic structure doctrine under the Keshwanand Bharati judgment. So under this doctrine, so what the Supreme Court has said? So Supreme Court has said that Indian Constitution has certain fundamental features. Indian Constitution has certain fundamental features. So those fundamental features are not subjected to the amendment power of the Parliament. So they cannot be amended by the Parliament. So Supreme Court has clearly said that any part of the Indian Constitution can be amended, but there are certain fundamental features. So those fundamental features cannot be amended by the Indian Constitution, because it could destroy the core of the Indian Constitution. So these fundamental features are considered as the core of the Indian Constitution. So therefore, those features should not be amended. So that is what the Supreme Court has said in 1973 Keshwanand Bharati judgment. And in fact, Indian Constitution gives the Parliament the power to amend the Constitution under Article 368. So under Article 368, Parliament is empowered to amend the Constitution. However, Parliament can amend any part of the Indian Constitution except certain fundamental features, as these features have been time to time provided by the Supreme Court. And in fact, it has been culminated in the Keshwanand Bharati versus State of Kerala case in 1973. Now, so far, the Supreme Court has given these different elements which are considered part of the basic structure doctrine. So what are those elements that the Supreme Court has given? For example, the supremacy of the Constitution. Supremacy of the Indian Constitution is considered as part of the basic structure. Apart from that, sovereign, democratic and republic nature of the Indian polity, secular character of the Indian Constitution, separation of powers between the legislature, executive, judiciary, federal character of the Constitution, unity and integrity of the nation, welfare state, judicial review, freedom and dignity of individual, parliamentary system, rule of law, harmony and balance between fundamental rights and directive principles of state policy, and the principle of equality. So therefore, these are the elements of the basic structure doctrine. Now, what is the significance of the basic structure doctrine? It is very important for us to understand the significance of the basic structure doctrine as well. Now, when we talk about the basic structure doctrine, so it protects the core identity of the Indian Constitution, because these are fundamental features, and fundamental features are the core of the core identity of the Indian Constitution, right? So in fact, the constitutional framers have included certain core principles in the Indian Constitution. So those, if you amend those core principles, it would destroy the Indian Constitution. So those core principles like democratic nature of Indian polity, socialist, secular and republic nation. Now in fact, Indian judiciary, or Indian Supreme Court is considered as one of the most powerful courts in the world, right? Because Supreme Court generally acts as the guardian of the Indian Constitution, and it also plays a very, very important role when it comes to the protection of the Indian Constitution, right? As its role, as its duty to protect the Indian Constitution, it has pronounced this basic structure doctrine in the Keshwanand Bharati judgment. So apart from protecting the core identity of the Indian Constitution, Keshwanand Bharati judgment of the basic structure doctrine also limits the arbitrary amendments made to the Indian Constitution. Okay. Now arbitrary amendments in the sense that whenever the government is having majority, whenever the government is having numbers in the parliament, then the government could actually make a sweeping amendments to the Indian Constitution, and that could potentially destroy the basic character of the Indian Constitution. But this basic structure doctrine is actually limiting the amending power of the parliament with respect to these fundamental principles. Parliament cannot make radical changes to the Indian Constitution. So that is how basic structure doctrine is considered as the guardian of the Constitution. For example, 99th constitutional amendment has been framed by the parliament. So this 99th constitutional amendment has been providing for National Judicial Appointments Commission. But the Supreme Court has declared the 99th Constitutional Amendment Act as unconstitutional, right? So unconstitutional because the 99th Constitutional Amendment Act has been violating independence of the judiciary. It has been violating the independence of the judiciary, and because of that particular reason, the Supreme Court has declared it as unconstitutional. Independent judiciary is also part of the basic structure doctrine as well. And apart from that, the basic structure doctrine also helps maintains the supremacy of the government. Supremacy of the Constitution. Remember that supremacy of the Constitution is also part of the basic structure doctrine. So the basic structure doctrine upholds the Constitution as a supreme law, thereby preventing its erosion by a temporary majority in the parliament. And in fact, this judicial, this basic structure doctrine will also play a very, very important role when it comes to promoting judicial review. So judicial review has been provided in the Indian Constitution as per Article 13, Article 32 and even Article 226 of the Indian Constitution. Article 13, Article 32, it has been provided for the writ jurisdiction of the Supreme Court, and Article 226 talks about the writ jurisdiction of the High Courts. So this basic structure doctrine, so it promotes judicial review because it empowers judiciary to review amendments and also strike down those who are violating the basic structure as well. And apart from that, it also protects the independence of the judiciary as well, that we have just discussed, that independent judiciary is part of the basic structure doctrine. And in fact, it very often prevents the encroachment of the parliament into the judicial space as well. And in fact, the directive principles of state policy. So directive principles of state policy, particularly Article 50 of the Indian Constitution, talks about the separation of judiciary from the executive as well. So we have discussed about the 99th Constitutional Amendment Act that was passed in the year 2014. So the 99th Constitutional Amendment Act has proposed the National Judicial Appointments Commission, and that was struck down for violating the basic structure of the Indian Constitution. So however, basic structure doctrine is not free from the criticism. It has been facing criticism. So we'll just have a look at the criticism of the basic structure. So it is believed that judicial activism is being promoted by the basic structure doctrine. It is not just about judicial activism, but it has also been promoting judicial overreach, judicial activism and the judicial overreach as well, because critics have been arguing that it grants excessive and unlimited power to the judiciary and allowing judiciary to subjectively define what constitutes a basic structure. And similarly, the vagueness of the constitution, particularly the basic structure doctrine, is also another major concern, because itself the basic structure itself unclear, and it has lacks a clear definition, and that has been leading to inconsistent application as well. And even through the basic structure doctrine, the legislative supremacy has been very often challenged as well, because this doctrine of basic structure has been weakening the principles of parliamentary supremacy in the law making. Okay, so a parliament can make amendments to the constitution. In fact, the Constituent Assembly has provided certain powers to the Parliament to amend any part of the Constitution. But however, the Supreme Court, through the basic structure doctrine, has taken away the unlimited powers of the Parliament or parliamentary supremacy when it comes to amendment of the Indian Constitution as well. The other thing is that basic structure doctrine has been nowhere mentioned in the Indian Constitution, and it is also lacking a statutory backing as well. So therefore, it actually raises key questions about the legitimacy and the credibility of the basic structure doctrine as well. And in fact, as we have just discussed, that basic structure doctrine curtails the amendment power of the parliament as well, because of the basic structure doctrine, parliament cannot amend the constitution as per its wishes. And similarly, this doctrine has nowhere mentioned in the Indian Constitution, thereby it has been raising questions with respect to its legal legitimacy and even its credibility as well. Right? So these are some aspects which have been surrounding around the basic structure doctrine of the Indian Constitution. However, the subjectivity aspect of the basic structure doctrine must be addressed. It should be more and more objective. And apart from that, the basic structure doctrine should also codified by judicial and parliamentary cooperation, so that it could ensure a doctrine truly acts as a safeguard against majoritarianism as well as the authoritarianism. Now, the overall objective of bringing in the the basic structure doctrine through the judicial pronouncement is to ensure that it is a safeguard against majoritarianism, and it is also a safeguard against the authoritarianism. Now, in this context, let's have a look at I.R. Coelho case and how this I.R. Coelho case has further strengthened the basic structure doctrine of the Indian Constitution. So this IR Coelho case is considered as a landmark judgment, and it is considered as a very important judgment that has further cemented the concept of basic structure, that has further enriched the concept of basic structure in the Indian constitutional law. So in fact, what are the basic features or basic aspects that has been pronounced by the Supreme Court in this IR Coelho case? Now, firstly, ninth schedule's power has been limited, because see, in fact, ninth schedule was brought in. A ninth schedule was brought in into the Indian Constitution to protect certain laws, which are challenged in the judiciary for violating a certain violating judicial review. Okay, so they could be challenged in the judiciary under judicial review, as they may have violated some constitutional provisions. So that in order to protect laws, so ninth schedule has been created through the first constitutional amendment, and certain laws would be included as part of the ninth schedule. And in ninth schedule, the court has ruled that laws added to the ninth schedule, certain laws which are being added to the ninth schedule, so that could offer extra protection from the challenge. However, those laws which are added to the ninth schedule after 1973, effectively after the basic structure doctrine of Keshwanand Bharati judgment, so those laws would be subjected to judicial review. So they are subjected to judicial review, and this is what the Supreme Court has held in IR Coelho case. Similarly, so the judicial review has been upheld by the Supreme Court in IR Coelho case, because the case has reaffirmed judicial review as a fundamental aspect of the basic structure, thereby ensuring all laws, even those in the ninth schedule, can be reviewed for their constitutionality. And even it is considered as a safeguard against the judicial overreach as well, because this judgment has solidified the principle that no power, including the amendment power, is above judicial review. This protects against the arbitrary actions by the legislature or the executive as well. And in fact, so it has also given judgment for preserving the core values of the Indian Constitution, right? So it has held that amendments which breaches Constitution's core principles or core values would be considered as unconstitutional, ultra-vires, wide, and safeguarding its essential features of the Indian Constitution, right? So this is what IR Coelho case had talked about. So now the next topic is the salient features of the Indian Constitution. So we'll try to understand some salient features of the Indian Constitution, right? So in fact, Indian Constitution itself has some significant provisions. They are considered as a fundamental elements of the Indian Constitution. Now, what are those fundamental elements of the Indian Constitution? For example, preamble of the Indian Constitution is considered as a fundamental element. Fundamental rights, fundamental duties, directive principles of state policy, and universal adult franchise, that is essence of Indian democracy, single citizenship, and also the separation of powers between the different organs of the government are considered as a significant provisions of the Indian Constitution, or they are even considered as a fundamental provisions of the Indian Constitutions, right? So as we have just discussed that preamble is also a fundamental feature of the Indian Constitution, because we have a preamble. So preamble, we the people of India having solemnly resolved to constitute, India is a sovereign, socialist, secular, democratic republic. So this is what the Constitution preamble has been talking about. right? So it is based on Nehru's, Pandit Nehru's objectives resolution, right? So preamble is based on Pandit Nehru's objectives resolution. And in fact, preamble also captures vision of Constituent Assembly and also the aspirations of India's founders, right? So it captures aspirations of India's founders. And even it also, universal adult franchise is also one of the significant feature of the Indian Constitution, because it embodies a democratic principle of one person, one vote, thereby ensuring the political equality of all individual irrespective of any discrimination or any distinction. Thirdly, single citizenship. We have the Indian Constitution has provided for the single citizenship, right? So this is unique feature as it grants all citizens the same rights and privileges regardless of their state of residence. So this is what is the single citizenship, and that has been provided in the Indian Constitution. And similarly, the fundamental rights as well. So part 3 of the Indian Constitution, from Article 14 to Article 32, talks about the set of fundamental rights for every citizen, right? So in fact, these fundamental rights are legally enforceable. That essentially means that any of these fundamental rights are violated, the aggrieved individual can approach the Supreme Court directly, and that is what is known as the legal enforceability of the fundamental rights. And in fact, the fundamental rights would consist of all the civil liberties, it consists of the political rights and also the fair trial procedures. And in fact, directive principles of state policy are also considered as part of the basic structure doctrine. Not basic structure doctrine. So they are also the significant provision of the Indian Constitution. So part 4 of the Indian Constitution talks about the directive principles of state policy. And these directive principles of state policy are non-justiciable guidelines. That essentially means that if these rights are violated, you cannot approach the courts for their enforcement. And they are also considered as a fundamental principles for the government to consider whenever they are making laws, whenever they are framing laws aiming to establish a just and an equitable society. However, so they are not directly enforceable by the court. They guide the state in formulating laws that actually promotes the social welfare in India, because the directive principles of state policy aimed to achieve or establish social and economic democracy. Social and economic democracy in India. So thereby it would result in establishing a welfare state, right? So it would result in establishing a welfare state in India. So similarly, fundamental duties which are prescribed in part 4A of the Indian Constitution, right? Part 4A 51A of the Indian Constitution. Now, fundamental duties, a concept that has been inspired from USSR, is an essential aspect of Indian citizenship, and they also emphasizes on the responsibilities along with the rights, thereby promoting civic morality and also the social cohesion as well. And similarly, separation of powers is also considered as one of the essential and most significant aspects of the Indian Constitution, because the separation of power is a fundamental principle that divides the government authority among legislature, executive and the judiciary. Now, in this context, we will make an attempt to understand the preamble of the Indian Constitution and its significance. Now, in fact, Indian Constitution has a preamble, and this preamble outlines or it mentions some core principles and its overall purpose, right? So in fact, Supreme Court has also mentioned that a preamble is a key to the minds of the constitution makers. This is what the Supreme Court has said. And in fact, Supreme Court also interprets the constitution in the light of the preamble. However, this preamble has been drafted by Vengalil Krishnamohan. So he is the person who drafted the preamble of the Indian Constitution, and it establishes "we the people" a source of authority, and it also defines India's character along with the Constitution's objectives. Right? So India's character is a sovereign, socialist, secular, democratic republic is India's character. Along with it also provides the objectives of the Indian Constitution as well. Okay, so it talks about justice, equality, liberty, and fraternity. So these are the objectives, and also ensuring unity and integrity of this country are some of the objectives. Now, what is the significance of the preamble? We have to understand the significance of the preamble as well. So firstly, the source of power or the source of authority for the Indian Constitution is "we the people of India." So thereby it has established the democratic foundations. It has resulted in establishing the democratic foundations in India, saying "we the people of India." So preamble also defines a nation. It also defines India as a sovereign, socialist, secular, democratic republic. Thereby it has outlined some core principles of the Indian Constitution. And in fact, the preamble also set some goals as well. So these are considered as a fundamental goals of securing justice, right? So they are fundamental goals through which we could secure social, economic, political justice, such as liberty, equality of all citizens. And in fact, it has also, considered as a guiding light for the interpretation of the courts, interpretation of the Constitution by the courts, because the courts are also several times have taken preamble as a guiding light for the interpretation of Constitution's provisions and also the legal disputes as well. Right? So it also reflects certain ideas, because it reflects the idealistic vision of the constitutional frameworks for just and also an equitable society. So here we have to understand the amendability of the Constitution, whether Constitution can whether the preamble can be amended or not. So that is what we should have to understand here. And in fact, in 1960s Berubari Union case, the Supreme Court has held that preamble is not actually part of the Indian Constitution. Since it is not part of the Indian Constitution, so Parliament cannot amend the preamble, right? So this is what the Supreme Court has held in Berubari Union case of 1960s. So it is a limited amendment view of the Supreme Court on preamble. However, in Keshwanand Bharati judgment of 1973, the Supreme Court has completely changed its stance with respect to the amendment power of the Parliament, amendment of the preamble. So the court has reversed its position. It has declared that preamble is part of the Indian Constitution, but in Berubari Union case, the court has held that no, it's not part of the Constitution. But in Keshwanand Bharati judgment, the Supreme Court has held that it is part of the Constitution and it is subjected to amendment, provided that the amendment that has been made to the preamble does not violate the basic structure of the Constitution. This is what the Supreme Court has held in the Keshwanand Bharati judgment of 1973. So this is the amendability part of the preamble. However, in conclusion, you could write that, a preamble embodies the core principles, the values of the Indian Constitution. So those values, the core principles which primarily guided India's freedom struggle. So thereby it serves as a foundation for India's democratic structure, the democratic nature of Indian Constitution. So therefore, these values which are enshrined in the Indian Constitution, they are very important. They are fundamental for nation's progress and also pursuit of justice, liberty, equality, and fraternity. Right? So this is how you could write a conclusion for any question which is being asked about the amendability part of the India's Constitution. Right? So that's all in this lecture, and thank you so much. So in coming classes, we will be discussing some more important topics for the exam point of view. Thank you.